things. And of course, mark you, in this business of adjudication, you have to deal with the prosecution aspect to the end before the defense can open its case. I want to repeat myself. You have to deal with the prosecution completely before the defense can open its case. And once the prosecution aspect opens its case, the prosecutor, and says, you, so and so person, sundry offenses, types of indicated in the university regulation, that is regulation TAU/003, regulation TAU/005. Law of the university, contrary to regulation this and this. Then he would put it to the offender. Are you guilty or you are not guilty? The offender Now, when the defense opens his case, he's still going to take the same process. He's going to call all his witnesses and begin to cross-examine them, which is also called examination in sheets. And he will tender all exhibits. The prosecutors too will now start to cross-examine even the witnesses of the defense. And even the members of the panel have the right to cross-examine the witnesses of the defense too, like they could cross-examine the witnesses of the prosecutor. And when everything is satisfied, that the defense has closed its own case, then it is now left for the panel. Next slide, please, which is the summary this time around. In summary, that is where the adjudicator has to put his experience, his expertise into play. It's not a job for a lazy person. He has to sit down now and do a summary of the whole process. He will take it and say, this is a case of so. For instance, can we say willful damage to university property? This is a case of willful damage to university property. So person has been alleged to have damaged university property. The prosecutor has said so and so. The prosecutor has tendered so evidence. The prosecutor witness 1 PW1 has said so and so. The PW2 has said so and so. The PW3 has said, all to the end. All the witnesses have to be talked about by this chairman of the panel now. In this case, the university disciplinary committee chairman has to do the summary and take his audience through everything that has happened. This is a case of, my example, willful damage to university property. So the prosecutor has said this and this. When PW1 said this, this was the reaction of the prosecutor. This was the reaction of the witness for the question put to PW2. This was his reply. If he finishes with the prosecutor aspect, he goes to the defense. When the defense opens his case, he says so and so from the defense witness 1, 2, 3, and so on. This was what he said. He will do a summary of the whole thing that has happened in written form, beginning to quote all that has happened from the beginning of the education to the end. That's the summary. And now say, what is the findings? What is his findings? His findings is that, is this offender, is he guilty or is not guilty? That takes me to some terms that I use here. In this kind of administrative procedure, which is adjudication procedure, you are not in the law court itself. You are not allowed to refer to anybody as suspect. And you cannot say an accused. No, he is an offender, but he's a defendant. The prosecutor too is a prosecutor. He is not entitled to a lawyer. I hope it is clear. So now he has to say whether the person is guilty or is not guilty. That is the findings of the committee or the chairman of the committee. Now, what is the findings? The offender is hereby found guilty as charged, or is found not guilty. That will be the verdict. But if he's found guilty, then he goes ahead to look at the provisions of the rules and regulations under which the person has breached the law. He wants to find out whether the person has breached the law or not, and he says he's guilty. And he goes ahead to pronounce punishment. Whatever the provision of the rules and regulation of the university is, he pronounces, oh, the offender has to go, if he's a student, 1 semester, in suspension, goes for what? Rustication, he's a staff, goes for suspension, termination of appointment, if he's a junior staff, whoever that person is, the same pronouncement is given. And the offender too has right of appeal to the university council within 14 days. And of course, if the appeal is upheld, adjustment could be made, and then the vice chancellor will report back to the offender the verdict of the appeal body. Thank you very much. I think at this juncture, my colleague Barrister Italoye will come in to do his own aspect. Thank you very much. Thank you.
Once again, let me join my, I don't want to say my colleague, Baba Olorumola, because he's our father, he's a grandpa, for that wonderful presentation. And let me join him as well to thank the organizer of this program, starting from the University Vice Chancellor, the management staff, other staff for this wonderful program. I also want to thank the organizer as well. Thank you very much for the opportunity. Yes, let me move quickly because of the time to my own area. Now, let me say this. One thing that you must understand about law is that law always believes that one day there will be problem. That's the way law reason. But that problem may not come in the next 100 years. But law always believes that one day there will be problem. Anything you do, wherever you go, even as you are seated, law always believes that one day there will be problem. That is why for everything we do, we have law that guides us. And we have law in place to guide activities of everyone in the society. Now, what Baba Olorumola said is more purely on the civil matter. Now, let's quickly talk about the core criminal aspect of it. Now, the first question that should be asked is this: is the university having 100% power to deal with criminal matter in the university exclusively? Please mark the word exclusively. Now, what is important that you must note is that university as an institution is having a tripartite role. They have a role to the community. They have a role to the students and their parents. Then they have a role to be played to the society. Now, in this context, the society we mean here, we mean they have a role in ensuring that there is peace, orderliness, and tranquility in the society. How do I mean? Now, I mean that it is expected that there are some offenses that even though the university can deal with them, that it does not end here. And I will tell you why. But let's continue. Now, when you look at the number one on the slide where I am, has to do with a position of law on criminal offenses before Student Disciplinary Committee. Now, as we all know that Student Disciplinary Committee is a body set up by the university authority for the purpose of carrying out investigation on whether a particular student should be recommended for a particular punishment, having gone through the necessary procedure and requirements. Now, imagine a situation whereby a student is involved in the use of drug on campus. Imagine a situation whereby a student dressed like a female student and he entered into female hostel and he raped. Imagine a situation whereby a student decided to lure his colleague to a dark spot in the university and he dispossessed such student of his property. Imagine a situation whereby a student of a university, in this context, our university, decided to hijack the process of examination. What will happen? Of course, our law in the university allowed the student disciplinary committee to take action, but it does not end here. I am speaking properly the way it should be in the eyes of law. I said something earlier on that the university is having role to the public. Now, imagine a situation whereby a student appeared before student disciplinary committee, and the student disciplinary committee, in their rights or in their investigation, discovered that such student actually brought in or surreptitiously brought in an item that is not in conformity with the university prescription on what student must bring in. Such student, of course, will be recommended for disciplinary action. But it shouldn't end here. This is why. Because the society is expected that the university should contribute its quota to how the society can be flushed and get rid of people that can create problem in the future. Now, when you look at number 2, say the University Senate had power to suspend any student pending the outcome of investigation, prosecution of alleged case of examination malpractice against him or her. Now, we cited some cases there. Deliberately, we put it there because in the event of things, in our pool of research, it has shown that some universities in Nigeria, they have more cases at hand. One of them is the University of Ilorin. I don't know why it is so. But we have so many low-cost classical cases from that university. Now, the point is that, for example, one of these cases here, the case of University of Ilorin against Uluwadare, it has to do with issue of examination malpractices. Now, what happened was that the student was involved in act of examination malpractices. And of course, the university dealt with it according to the University of Ilorin Establishment Act, KPU Laws of Federation of Nigeria, 2004, of course. But because the university did not do the appropriate thing, that was why the matter went to court. Why? As soon as the university concluded investigation, of course, there is nothing that says that the university cannot go ahead and do according, as it is expected. But they are expected in the eyes of law to hand over such students to appropriate law enforcement agency for further investigation. The reason is very simple, as I've said earlier on. But experience have shown that in most cases, universities don't want to do this. They will always want to handle things in their own way. Of course, the way the university do handle it is completely correct, but it's a means to an end. It is not an end there. This is why we have so many cases in court that you will see people going to court, they will say they did not give them fair hearing. They did not give them fair hearing. Why? Because they believed that what has happened did not follow the normal procedure. And the only way the university can block that is to ensure that after they had carried out necessary investigation, then they suspend the student and forward the matter to the appropriate law enforcement agency. Please, next slide, please. Yes. Now, when you look at it again, the question to be asked is that, why is it that the university, apart from that, they're always interested in handing it there without taking any further action? The university, in most cases, normally do this for 2 or 3 reasons. Now, reason number one is that the university believed that, they will always believe that there is need for them to concentrate on the primary duties of the university. The university do not, in most cases, want to spend money, time, energy in prosecuting matters because they will be invited, appropriate staff will be invited to come and testify in court. So they believe that the best thing they can do is to suspend the student. In fact, in most cases, they may expel the student. So that is exactly what that aspect is all about. Yeah, thank you. Now, another thing that is very important that I want to quickly speak on because of my time is the fact that I haven't speak about the students. There is need for us to understand that even staff, they are subjected to the law of the land as well. Of course, we understand that where a staff is involved in some acts, the university has power to deal with such staff. But where what staff has done has a criminal connotation, colorization, it does not end in the university. Imagine a situation whereby a lecturer, or let's say lecturer because I understand that you know, when a lecturer set question, you send this to the HOD, from HOD to sub-dean to dean, just like that, the way you understand the way it is. Now, imagine a situation whereby a lecturer just surreptitiously gain access into the pool of questions and leak it to students. In such situation, it's a criminal, it's a classical criminal act. Imagine a situation whereby a lecturer is involving himself in the molestation of students, female students. Imagine a situation whereby academic staff is involving in the act of helping students to do internet fraud. These are the acts that needed to be looked into. So in such situation, it is expected to follow all the necessary procedure that Baba Olorumola have said, yes, it is expected to follow it. But the question to be asked is that does not mean that the university cannot exercise its power. But the university is expected to carry out another round of forensic analysis to actually determine whether this offense in question or offenses is of the one that has a criminal connotation. For example, when you look at the law of the land, for example, when you look at the Kwara State Examination Malpractices Act in the Educational Institution Prohibition Law of 2018, it specifically mentioned in that law that all the institutions in the state are bound by that law. In other words, that those are the aim of affairs in the state, in all the institutions, higher institutions in the state, are expected to commence the process of adjudication on criminal matters on their respective campuses, but it must not end here. Then again, when you look at the Examination Malpractice Act, CAPM, Laws of Federation of Nigeria, 2004, he also said the same thing. So what it means is that in a situation where you are expected, where the university is expected to focus on the disciplinary measure, they have to do it in such a manner that it makes it look as if it is not the university business all alone. Of course, it's a different ball game. If a lecturer, if a student, for example, did not wear his ID card, if a student decided not to enter the hostel at the appropriate time, maybe 10 o'clock, if a student decided to be roaming about when others are in class, because I remember some time ago, there was a rule on the campus that says that between 8 in the morning and 3 in the afternoon or thereabout, that students should not stay inside their respective hostel. Those ones, they are domestic affairs of the university. The university has total power to deal with such situation. It has been established in a line of authority, plethora of cases. It's just I cannot be citing cases, but I provided some in all these places. If you look at the case of Esiaga against University of Calabar, it was established there that the university in their wise has power over the domestic affairs of that happen within the university. That the university is not expected to fold its hands and allow things to go out of hand before taking necessary measure. And that every member of staff in the university are expected to play one role or the other. In other words, the message that we are expected, or part of the message that I respectively want us to take back to our various departments, faculty, our institution, our wherever we are from, non-academics as well, is that I want us to go with the package that's in the course of ensuring that orderliness is reigning in the university. It is the business of everyone. All of us cannot be in, for example, student disciplinary committee. Everyone cannot be in the staff disciplinary committee. But what I am saying is that wherever we find ourselves, or wherever within the campus, we have, under the law, we have every right to watch out for anything that can contribute to the decrease in the activities on campus. And immediately we spot any of those things. The law is that we have to report it. Thank God we have our Dean of Student Care here. It is our duty in ensuring that we do that. So let me round off by saying that the criminal adjudication on disciplinary measure on university, it is something that is important. It is something that is so significant to the extent that everyone is expected to play a role, particularly those that are saddled with the responsibility of managing the affairs on campus. Therefore, I want to say that when it comes to criminal matters, the university is having right to do the needful. But however, it is not an end, but it's a means to an end in itself. Thank you very much.
Thank you very much, sir. That was an insightful presentation. And without wasting too much time, I want to open the floor for questions. Let me take some questions from the audience while also waiting for questions from colleagues who have joined online. Questions from the audience. I would only take the question once. So if you have a question, please kindly raise up your hand so that we'll not duplicate it. We already have time bound. We're already running out of time. So I'll take Dr. Razak first, and then I'll take, please remind me of your name, sir. Sir Batunde from Criminology, and then I'll take Mr. Omojarabi, and then Prof, sir. I'll take, okay, sir, I saw his hand first. Dr. Abegunde, I hope we are going to go here today. I'll take your question too, sir. Mr. Ahmed, then I'll take Prof, then I will take you, sir. So I think I should give the number again. Dr. Razak 1, Mr. Batunde 2, Mr. Omojarabi 3, Dr. Abegunde 4, Prof 5, and then Mr. Ahmed 6. So I want us to be brief and go straight to the point. I also have my questions as well. Thank you.
Thank you so much. How I wish we had time for this subject matter. I'm going to start with an illustration, but finally my premise, then I'll ask the question. Now, I've experienced a situation in which a student was accused for taking drugs. And the parent was called to come and pick up the students. And the father told the management that when he brought the student to school, the student was not on drugs. That now his boy is on drugs. And therefore, the school should find a solution to that boy. That is one. Number two, NUC will tell you that no university have the audacity in their disciplinary file to accuse or punish a student for drugs. They will tell you that. All right? Therefore, do the university have the audacity, I mind my words, to punish a student for drugs without moving that case to And dearly. That is one. Number two, a student was on IT and his roommate was accused of exam malpractice. They cracked the internet to get the exam question of a professor, and the student was not on campus, he was on IT. But it was his own system that the roommate used to crack that exam question. And the student was accused for exam malpractice. And they called him to come and open up his system. Now, because they couldn't get the system, they cracked it, and they found out that it was his own system that the original culprit used to crack the system. And when he returned, the mother sued the school for asking the son to go home for malpractice. That, again, what is the position of the law in terms of accusing you of shaving your head in your own absence? That is the question. Thank you so much.
Thank you very much. I think we should take all the questions together so that we can give answers to it. Do I have that permission? We should do that. All right. So that because of our time, the second question now.
Good afternoon, everybody. My question is about you. What is the place of presumption of innocence? Because, okay, that's one. Two, do the student really have a fair hearing? Do the school really follow due process in the case of their adjudication? And what is the place of a juvenile among these students? Because some of them are not criminally responsible according to their age. Thank you.
When you want to commit crime, you use a lawyer to commit crime. Cases that we have treated in student disciplinary committee, some of those that are here will bear me witness. I, in my mind, used to think that some of the students were coached because of the responses. And this is one of the reasons why. So if somebody comes to SDC and say, I am 14 years old, then it becomes another case. So the laws are, please help us to clarify that. Number three.
Thank you for the beautiful presentations to our speakers. While the first speaker was making his presentation, I mean, Dr. J.J. Olorumola, he said when one commits an offense and the offense is not known to the law, then one has no offense. I think he's trying to state a principle. So this question raises a kind of its applicability in both theoretical and practical context. Now, my question is this. When an individual commits an act that is not explicitly prohibited by law, can the person be held criminally responsible?
Thank you. All right. The next, Dr. Abigunde.
Thank you, sir. I want to read from the second sentence of Barrister Italoye. The University Senate has power to suspend any student pending the outcome of investigation or prosecution of alleged case of any offense. Sir, I want to ask about the provision of the law and the role of you law officers on a situation like this when a student has been suspended from the school, possibly for a semester, or somebody has been accused or alleged of committing a particular offense, and the person has been put in police custody for a certain period of time, and upon concluding the investigation, the person now is found to be free, innocent of that particular offense. What is the position of the law to compensate that person for the period the person has lost, especially a student that has been suspended for almost a semester? Thank you.
I think the law people, if they go to court and win, they know how to pull off damages. I don't know anyway. Prof, sir.
Yeah, thank you very much. I want to thank the two speakers. Starting with the second speaker, I guess what the second speaker was trying to emphasize to us, if I'm correct, is that cases handled by universities may not necessarily end with whatever penalties or consequences the university wants to met out, particularly when you're dealing with criminal cases. That is understood. That is understood. But you did not tell us when and how the university should proceed should there be any such case. That's one. So the first speaker, I want to find out, are you advocating that the university, taking this university as a case study, are you advocating that we should begin to employ total adjudication process as you have stipulated, considering the fact that institutions, whether parastatals, agencies, even private corporate organizations, have their laws that guide them. And that when an individual is coming into such organization, you are told, you are mandated to go through those to know the do's and don'ts. Now, if a situation arises and someone now breaches the law, as it affects that organization, in this case, the university, if we begin to go through the adjudication process, will you, sir, have time to teach? Will you, sir, have time to do research? Considering the fact that every day we have cases, particularly on the side of the students, we have them coming up. This morning, I have one that the student care, the director of student care will be receiving. If that is so, are we going to have time to complete our assignment, primary assignment here, knowing fully well that we have a law, and the law says if you slap someone and it is proven that you slapped someone, this is the consequence. Do we need to call witnesses and go right and left and go forward and backward and go top and go bottom to prove that someone slapped someone, to prove that someone took drugs? Do we need to do that? When all I need is a sample from you, and in the next 1 hour, I can pronounce that the drugs were found on you. Thank you.
Thank you very much, sir. Dr. Shola, please kindly permit me to please take your question after the program, sir. I'm very sorry, sir, because of our time, sir. Can we take these answers in 2.5 minutes each? Okay, you want to start with that, sir? All right, sir. Please, we have just 2.5 minutes each.
Thank you very much.
Apologies. We have one more question, sir. Yes, sir.
Thank you so much, the speakers and the rest of my distinguished colleagues. I will ask this question from the angle of the students of Thomas Adewumi University. For instance, to some extent, I have been familiar with the rules guiding the operation of the students of Thomas Adewumi University. The question goes thus, sir. In the case of examination malpractice, the rules specifies the duration to which the accused must be investigated and the report should be read. But in other cases, like assault, stealing, and so many others as the case may be, there is no way that the rule states that this investigation must be carried out within 2 hours, within 24 hours, within 1 week or thereabout. Is there any duration recognized by law that PI must take place within? Thank you, because it brings about issue of delay in investigation. And we're talking of procedure and proceeding. You are in a hurry because you want to please one person and you fail to do the right thing. At the end, the legal implication will be awaiting, will be awaiting the university somewhere. So in order to avoid issue of delay in carrying out investigation, is there any specified duration to which investigation will have to last or be worked within? Thank you.
Very interesting question. I think I'll be guided by the moderator, whichever question he asks me to answer. Though I'm interested first in my very senior colleague and father, Professor Emenike's question regarding whether I'm advocating for proper adjudication procedure in the academia. Of course, my answer is yes. Because if you marry Dr. Babatunde's question with that of Professor Emenike, Babatunde said, do we observe fear here in the university? To observe fair hearing, of course, due process has to be followed. Now, in domestic, just as in international law, the reason why people don't seek justice most of the time, according to Ellen Shaw, is because the process of seeking justice is long and cumbersome. You can imagine, I say somebody broke the glass of my, side glass of my car, and I take the person to court, and the court adjourned from January till September of that year. And you see, and the court is adjourning till July of the next year. So whether you are talking of domestic or international law, that's one of the discouraging factors why people don't seek for justice. If we continue on and on here, we shan't live here today. So you have to do fair hearing. And in case you don't do fair hearing, our advocation here is that parents or individual can take you to court. And you'll be asked to produce your adjudication book. You'll be asked to produce the procedure, the proceedings. Don't think whatever you do here is final. You can have, can I say, difficult parents who can take you to court. And don't forget, moderator, we already said, is it slide 3, that where the offense is of criminal nature, the case will, after investigation, we refer to the appropriate law enforcement agency, for example, the Nigerian Police Force. I don't know whether I've answered Prof's question. Please. Thank you
very much, sir. Barrister Italo, sir, please answer to those questions. We would love you that you are detailed and explicit, succinct at the same time. Thank you.
As fast as possible. Number one is that let me quickly add to what Baba have said. Now, I always say this. Every matter before adjudication body, administrative adjudication body, is a potential matter for Supreme Court. Maybe you don't know. It's a potential matter for Supreme Court. Now, a matter that gets to Supreme Court starts little by little. Therefore, in law, there is what we call writ of certiorari. What it means, I will explain. What it means is that it is the order of higher court directing the adjudicating body to bring all its record for the purpose of vetting it and look into it, whether they do the appropriate thing. Now, imagine a situation whereby they rushed everything. They will quickly set it aside. And people will now come around and say that law, the court, they did not do the right thing. So that is why we need to have our patience. Now, let me quickly answer the question. Number one is that our doctor of the dean postgraduate asked a question about the issue of drug-related sin, and how is this? I mean, how it has to do with the university and that moving needs to end early. Yes, like I said earlier on, sir, in one of the slides, because the university in most cases don't do the right thing, that is when the parent of all these students developed unseen and overnight power to be challenging the university. Imagine they had referred the matter immediately. Then it will now be a battle between that student and appropriate government agency. But where the university decided to be handling it in their ways, maybe because they don't want to spend money, resources, and and all that. That is why something is on me. It's always like that. Well, on the issue of a cracked laptop, professor and all that, again, that is why the matter has to be referred to the appropriate law enforcement agency. In this context, it could be referred to the EFCC. It could be referred to the ICPC for proper investigation, because they are the one in the eyes of law. When you look at the EFCC Act, they are the one that have the facilities, the time and energy to dig deep into this particular area. So let me move to the next one now on the issue of presumption of innocence. Now, when you look at Section 36 of the Constitution of Nigeria, it talks about right to fair hearing. That is, everyone is presumed to be innocent. You understand? Until proved otherwise. What it means is that I want to believe when you go to our faculty of law, you will see one status there. We call it Lady Artemis. He blocks his eyes like this. What it's saying is that, look, even if the matter happened right here before the eyes of a judge did not see it. Yes, until when it is proved. Now, imagine if your brother or my brother is a person that is wrongly accused of committing a crime. And because we say we want to rush it, on that side, what are we going to say? We say law did not do the right thing. But because another person is at the receiving end, then we will change our story. So that's that about that. Then quickly move to the issue of fair hearing and adjudication. Yes, I've answered it the other time that when you talk about fair hearing in law does not, in fact, that fair hearing alone, Section 36 of the 1999 Constitution, when we take it under constitutional law that I take, in fact, we can take 3 weeks, 3 classes, yes, in teaching that Section 36 alone of the Constitution. So because it's so wide to the extent that when we say fair hearing, it's not that you come and you talk and you go. No, it's how to do with giving you facilities, time, energy to prepare your case. Because we say in law that a case rush is a case quashed. Because when you rush it, it will be quashed. And one thing that we know in law is that we say where law is against you, use fact. And where fact is against you, use law. So if you do not, if the adjudicating body did not therefore tie their rope very well, did not do what is right, I can assure you that the matter is likely to be set aside on appeal to the higher court. That was why I started by saying that every potential matter before the administrative adjudicating body is a potential matter for Supreme Court. Don't forget that I told you earlier on that there are cases of University of Ilorin. We have so many of them. It started from the university. It does not start, it didn't start from the court. It started from the university. So sometimes the university don't envisage. Sometimes people at the end of affairs in our university believe that let's just do it quickly and move on. In the process of doing it quickly, you will leave a lot of things undone. So thank you about that. Then, second to the last, and the next one, a question was asked on the issue of a juvenile and criminal responsibility of age. Now, quickly, I will answer that. Now, when you check Section 1, subsection 2 of the Kwara State Examination Malpractices in Educational Institution Prohibition Law, it says that any person that has not reached the age of 18 and he committed an offense of, for example, cheating in an examination, that person will only be entitled to pay the sum of 20,000 naira. Yes, now that's what is in the law. But where the person is above the age of 18, he will be convicted for 3 years plus the payment of that amount. But where the person is a lecturer, supervisor, and all that in the university, that particular person will be convicted and he will pay the sum of 100,000 naira. Now, the question to be asked is that how many of our university take cognizance of that? That is why some of them will come around when we ask them, what is your age? They will say, I'm 14. Because don't forget that some of these children, we are now living in the era of artificial intelligence. Some of them, before they commit that offense, they will have Googled it to know what the law says. Okay, if I say I am less than 18, then if at all, if we drag it up and down, then the law, they will ask me to pay this amount without going to prison. That is why I said it when I started that our people that are the aim of affairs in giving admission, they too should be very careful. I said something the other time that every matter in university is a potential matter for Supreme Court. So when we are giving them admission, we should also take that into cognizance. That are we sure this particular person is 16 or 15? So when we do that, for example, one of the advice or recommendation is that where you discover that the age of a particular student is in doubtful, there are things to do. The university knows what to do, so they should look at the law and do the needful. Then let me quickly answer this one before I stopped. Yes, this question is about the issue of wrongful suspension of students. Now, sorry, students that were suspended, probably the investigation revealed that he did not do the offense. He did not commit the offense for which he is alleged to have committed. Well, before they can come to such situation, the matter must have been thoroughly investigated. And what it means is that where a student is said not to have committed an offense, of course, number one thing, that's why it is always advisable for university not to rush into conclusion of expulsion. Because what if at the end of the day, they go to court and the court says he did not commit the offense? How do you reverse the irreversible? Because at that point, the student must have been blacklisted, pasted his name here. And don't forget that some of these things, when they paste it, when you snap it, you can get to where you yourself cannot reach. So at that level, the fact that the university did not expel him, technically speaking, is a way of giving a gap for what we call apology by way of or through letters. For example, where the court says that he's not guilty. Maybe something happened, mixed up somewhere. Then the fact that the university absolved him back, the university can write an apology letter, or the university has a way of doing things and restore him. That is when we have our fathers in the psychology philosophy that will come in, try to talk to him for emotional balance and to make sure that he's not depressed and all that. So that is that about that. I think I've been able to, yes, okay. Some of the questions are repetitive in nature. Let me stop here, but let me quickly add this one more thing. Sorry, sir. Now, let me add this, that when it comes to issue of adjudication on criminal matters and civil matters in the university, they are two different things. And we must be able to understand it. The reason is that as we are here, and for those that are watching us online, you could find yourself in any place in future where you will have to represent a body, organization, institution, and you will know what to do. That is one of the reasons why we are here. Thank you very much.
Thank you very much. Please, before you go, sir, let's give a round of applause again to the lawyer. Thank you, sir. I just want to cite this case because it's a fresh case. Possible you are not aware of it. A few days ago, today is 28, I think it was 27 or 26, JAMB issued out a new regulation. And there are two things in that regulation. The regulation is targeted towards exam miracle centers. The regulation came from the Ministry of Education that henceforth, any miracle center course should be deregistered for a number of years. Additionally, any student caught in exam malpractice will not be permitted to write WAEC, NECO, or JAMB or NAPTEP for 3 years. And then for 3 years, it means such student using the instrumentation of NIN. Now, there are some cases on ground. It is because of these cases on ground that made JAMB to be forced to do the investigation they did because of age issues. Now, I know what I know lawyers do. There are good lawyers and the other side of lawyers. And what I mean good lawyers is that if a lawyer is to stand for somebody in court, they listen to you so that they will see the loophole in that person's case or the procedure for them to win the case. I am beginning to think, because a parent specifically reached out to me last time, that if the student cannot get admission because of 16 years old, and they will just go to NIN and increase the age or change the age. Are you not thinking that with this new regulation, students and parents will now begin to think fast and exploit the change of their ages through NIN? Now, if that happens, is there a punitive measure on NIN? I don't know the NIN rules and regulations, because this is a very good area to pursue. If somebody is saying, I don't want to go for 3 years to regulation from not writing exam, I cannot sit for SAT to travel out. That is another area that can be addressed. Secondly, there's something that we have not addressed here. While we were preparing for this program, this event, one of the things that convinced the units, the human capacity development, is to educate members of staff that, okay, if an issue happens to a university staff member, whether at the administrative level or not administrative level, the law states that before, for example, an head of department should issue a query, the case must be investigated. What is the position of the law on that? If, for example, now somebody in my department is supposed to go to class and the person did not go to class and somebody now fails the course, you didn't teach a student for the whole time, somebody fails the course, I just go to the boss and say, peg his salary for 1 month, and the person goes to court. What is the correct procedure? I want you to set it right. Thank you.
Let me quickly speak about the second one. Now, on the issue of a directory power given to the head of department or HOD, as the case may be, to investigate before giving query. Now, the point is this: he's still teaching towards the ideal of fair hearing that I mentioned the other time. Because when you talk about fair hearing, it is so large to the extent that you cannot close it. Now, for example, a lecturer that's supposed to be in class and did not come. Now, I want to restrictively assume that there must be a reason for that. Particularly if the record revealed that he has not been doing that before. Now, if the record, because I want to believe that whether orally or in terms of written down, the university, in quote, through the appropriate bodies, are keeping record of how they are lecturing students. Now, they should be able to go and look into that. For example, where a lecturer did not come to class as a result of maybe he's under the weather, as they put it, he's sick. Let me use the language, because in law, we don't hide language. We say it straight, away the way it is. If somebody is sick, for example, and he cannot come to class, then I don't think it is worthwhile to issue that person query, except if there is more to it than meet the eyes. Then apart from that, the question to be asked again is that how many of our lecturers or staffs are having access to our rules and regulations? That's another question to be asked. Of course, we know that we say that ignorant of law is not an excuse, but there are exceptions to it. So don't let us go into that one. Now, let me quickly go to the issue of age. I had it in the news this morning, newspaper, what the paper said, review this morning. I had it because I do listen to all those before I leave my house every morning. Now, what came to my mind is that a regulation, then Act of National Assembly. You understand what I'm trying to say? The question is not even to what extent can they apply that over 16 years of age. The question is where somebody utter things or something like that. The question is, what does the Act of National Assembly that set up JAMB says? Now, don't forget that what we are talking about here, from the colorization of what I had in the news this morning and from what you have just said, it has a criminal colorization in it. That was why JAMB took that decision. But the question is, where somebody is caught in the act of examination malpractices by whatever name called, is there a law that punishes that? Of course, there is a law. So since there is a law, don't be surprised. I can assure you that before the end of next month, they will challenge that law, that rule in court of law. They will challenge it because the point is that there are laws on ground. An administrative body under administrative agency under executive cannot just come up with any rule. It's very simple. Whenever there is a clash between rules and act will prevail. Whenever there is a clash between law of state and act, the rules of a state will go on abeyance. We call it doctrine of covering defeat. Act will cover. But whenever there is a clash between act and the constitution will prevail. So the question is not even 16 or whatever. You understand? But let me answer your question straight away before I drop the mic as a concerned Nigerian citizen, before speaking as a lawyer. Or don't let me speak as a lawyer. Ordinarily, when a parent decided to adjust the age of a child, jack it up, as the case may be, maybe that child is originally 15, but because they want that child to enter or gain admission into university quickly, they go to NIL by whatever name called where they do all those things. That is a criminal offense for NIN. You understand? When you altered a public document, alteration of public document is a criminal offense. That's that. But for that child, thank God our father is here, who is a psychologist. They know the implication on the psyche of that child. Even when they when the university give admission to such child. That's why when you go to some of our department, faculties, you will see some students. Even when you ask the student, read this thing and repeat what you have read, they will not be able to say it. In fact, it's true. For example, I'll give you an example quickly. Yesterday, when we were doing a particular course, I asked a question from one young lady. You read it? I said, yes, you have read it now. Explain to me what you have read. She almost cried. I had to face another person because I don't want to see. You understand? So what I'm saying is that, one, it has criminal colorization. Two, it has emotional colorization. And three, it has a psychological colorization. Thank you very much.
Thank you very much. A very beautiful round of applause.